I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we are discussing cybersecurity incidents that present in the form of unprompted security, quote unquote, researchers. It's a fairly common occurrence, and it may happen something like this. The general privacy or cybersecurity email inbox receives a random note from an unknown individual announcing that they have found a way to gain unauthorized access to company data or into a company's system, app, or service. Sometimes they say they want to help. Sometimes they ask for money. Sometimes it's unclear what they want and whether it's all just part of a fraudulent phishing campaign. And in fact, sometimes they are encouraged to contact you through formal bug bounty programs or other incentives that reward white hat hackers who add value by closing cyber backdoors. Also true is that while these events come in many different varieties, they are always scary and require a thoughtful, if not always clear, response. To discuss, I have invited my colleague, Dan Ongaro, as part of our Minneapolis office to join the podcast. Dan has a practice that focuses on cybersecurity and comes from a background in cybersecurity consulting. Dan, welcome back to the podcast.
Thanks for having me, Scott.
So, Dan, I tried to describe a little bit of my experience with these researchers, but you may have other ways of thinking about them. What is a security researcher, and should we think of them differently than just traditional threat actors?
Yeah, absolutely. It's a common conflation that happens when approached by a security researcher. And the security researcher differentiates from a threat actor in a few ways, although there can be some overlap. Security researcher identifies and analyzes vulnerabilities that may exist, whether it be in the software, the hardware, the networks. And when I say vulnerability, it might even be a misconfiguration where something is just turned on the wrong way. So there's like a data exposure that occurs. A security researcher is typically more focused on outreach to the company to help resolve and remediate the issue, sometimes with an expectation of compensation or recognition. A threat actor is going to be acting unauthorized in bad faith, really intending to harm a company's system or data, and maybe seeking financial remuneration, more of an extortion sense.
So, help me here, because in some ways they sound very similar, and in some ways maybe it sounds like they are qualitatively different. On the similar side, it sounds like both a threat actor and a security researcher has figured out a way of gaining unauthorized access to a protected system, or has gained unauthorized access or acquired data without permission of the company.
I'd say there's some of the nuance gets into another different term of an incident versus a technical vulnerability. So a vulnerability may exist, and many companies have vulnerabilities that are out at any given point on many systems. Think of it as oftentimes a security researcher is only bringing attention to that vulnerability, and isn't necessarily actively exploiting it. There are instances where if a researcher does some level of exploitation, it's typically meant to help prove to the company, you have this vulnerability out here, and here's evidence of how I was able to do it. And so you go and take it seriously and fix it. Threat actor, isn't so interested in raising that until after they've taken the data or deployed malicious software, gone beyond having a vulnerability exist to actually actively exploit it with ill intent. Oftentimes, again, so then either deploy malicious software or extort the company based on the data that was taken, or a combination thereof.
So Dan, it sounds like, okay, there's similarities in that both have engaged in some sort of unauthorized activity, and we'll get into whether there is an authorized version of that in a second. But let's just, for the moment, they've both engaged in effectively unauthorized hacking-oriented activity, but it sounds like the big difference between a traditional threat actor versus a researcher is the intent behind which they are engaged in that activity, and perhaps the way they communicate with the downstream victim of that activity.
That's a great synopsis, Scott. That's exactly right.
So, all right, who is the researchers that are out there? Big picture, who are they?
Yeah, there's some people that are solo practitioners. They maybe have developed some skill set. This is their side hustle in code. There are other folks who are more sophisticated. This is what they do all the time. Oftentimes, they may be abroad, and because of US dollar payments or other aspects, it's something that they can do as a full-time position. And then there are actual security research firms where this is a more sophisticated operation where they may have identified a more widespread item that they want to do proactive outreach. Oftentimes for those, they're very focused on the recognition to build their brand so that other companies will hopefully hire them for consulting and aspects in the future. So it really runs the gamut.
So could be anywhere from like this is a side hustle to their full-time gig. It could be anywhere from like this is the primary means of income versus that they're using this as essentially a sales channel to get hired for other services. Kind of many different ways. And is it also the case that sometimes you don't even know who they are?
Absolutely. Yes. There are a number of times where you don't know for certain who they are, at least early in the process.
So who is it that they target? And is that something that, companies say, okay, yeah, I'd sign up. Please go ahead and try to find some way into my systems so that I can close those doors? Or is this something like you just have a presence on the internet and so you are then subject to the security testing of these researchers?
Yes, Scott, it's absolutely both categories. There are companies who have proactively come out and said, we recognize that we may have vulnerabilities. We have established these programs that we very much want to publicize publicly and lay out expectations. A lot of times, especially thorough ones, maybe tech companies or groups that you would expect either make software, hardware items for them. Having someone come in and find a vulnerability can be very helpful upfront and much less costly than I was doing front-end research or just recognizing that there are use cases that transpire. And on the opposite end, it can be anybody who has any internet-facing device where they're able to tie that device back to the company, whether or not they have an established program or anything that would be publicized. To your point, you can get the random email to your privacy or other inbox, or someone in IT gets it. Again, really runs the gamut.
So I want to get into the legal implications of these types of interactions in a moment. But why don't we just kind of play one of these out together? Let's just say you mentioned person within the IT group receives an email and says something of the nature of, hey, I was able to compromise your consumer facing app to be able to gain access to all of this data, and please contact me immediately. What to do?
Yeah, the first thing I would say here is don't panic. As we discussed a little bit earlier, often we see these scenarios treated immediately like a critical incident, such as ransomware or a mass data theft, rather than thinking this could be in good faith security researcher, and then that somewhat can anchor the way the company proceeds forward. So beyond not panicking, the next step depends on a few key factors. First is, does the company have a vulnerability disclosure program, and what does it say? Second is, what did the security researchers say in their upfront communications? And third, what background intelligence can we get on the security researcher? So jumping into those a little bit, start with the text. Do you have a vulnerability disclosure program, and what does it spell out? What expectations does it say for security researchers if they're going to approach you? You're making sure that you're basically following what your program would have defined and thinking about how that may constrain. It kind of can set the tone of, if you say don't do X and the security researcher has clearly done X, then it's going to appear to be more in bad faith. And we can get more into disclosure program later in those statements and setting those expectations up front. Second item with the security researchers' communications, This is a really key piece of wordsmithing and looking at what they said and reading what the intent, as you said, the intent behind it. If it reads like extortion, this is likely not going to be something that's in good faith. If they're clearly coming out and making monetary demands up front, especially ones that are very large, you can be particularly concerned. Based on, have they given you enough information for you to validate the issue? And have you validated that in fact this is real? And what are the risks presented with this vulnerability? Is this something that is very standard and not necessarily risky, or is this something that really would, if truly exploited, present a critical risk? And did the researcher appear to operate within the terms of the disclosure program or standard ethics? If you don't have a program established, just thinking how a researcher would normally approach it. So final item, which often allows us to suss out the legitimacy of this, is security researcher intelligence. As we've talked about earlier, like some of them, this can often be one extreme end of the spectrum or another. We see people who are able to identify right away. They have a history of trying shakedowns, such as they'll go public after a very short time for very low risk items to try to basically shame a company into paying them, to a researcher who may be a very established name that has a reputation, has recognition from other companies. Some vendors, actually will track and see badges and recognition that people have. So a lot of that can sometimes be found just on public database searches, very easily. Other times we will work with law enforcement or threat intelligence groups to help determine more about what information we can gather on the security researcher.
Dan, as you're describing this, I just am thinking about it. Very much, it sounds like we're in a difficult spot because we're talking with somebody that we don't know, and we're trying to learn as much as we can about that person, including their incentives. And I had like this image in my mind of these medieval movies where you see these, two armies standing on a field in lines facing each other, and then they send out kind of their ambassadors into the middle of between the two armies. And they're both trying to look at the other person who's coming out to try to see whether it's safe, even though they're flying a white flag, as to whether I should be able to engage and trust in this person. And maybe it's something similar here, is that you're feeling like you're in a position where, I may have had a large breach, or I may have just been able to prevent a large breach, but I don't know until I start knowing more about who that other army member is coming into the middle of the field and what was it that I know or can know about them.
That's a very appropriate analogy. And again, you certainly, as one would imagine the circumstances, you proceed with professional skepticism. You don't want to think that this person is just always having the best intentions. At the same time, you do want to gather all the info you can to make informed decision with your army, whether you're going to go into battle or retreat.
All right. So I learned all of this, and, let's just say I haven't found any particular red flags yet. I haven't found any connection to our sanctioned company. I haven't figured out that this entity is a sanctioned. As far as I can tell, there's perhaps maybe limited, but also not anything that is limited information, but perhaps not any particular red flags that would make me think that the researcher is going to, betray us, betray any confidence, whatever it is. But we find ourselves in a position where, typically the researchers need to make money somehow. Could be for that consulting gig that you mentioned, but it also could be that they're asking for some sort of payment for their time and energy and for the valuable information that they provided. What does that conversation look like? And how is it that we on the legal end are thinking about a decision to pay for that time, energy, and information?
Yeah. So that decision in many ways is driven, or that initial conversation is driven in many ways based on what goals you're trying to get the conversation. There may be, the first bucket really quickly is pay. Either pay, delay, or don't pay are the three buckets. The first bucket with pay is going to be rare in practice, especially in early juncture, especially if you don't have an established vulnerability disclosure program. But in a situation where you validate this is legitimate vulnerability, there's no violation of our terms, there's reasons why we think that we should reward the actor, you may go forward. Again, if you don't have an established program, it's just going to be very rare, and we'll talk about what a payment may look like under those circumstances. Often at this point, your focus is almost more on delay because, to go back to your analogy, you're trying to get more information from this researcher and try to either better understand the tools they use, understand their intent. We've had several instances where, in this case, using air quotes, researcher/threat actor undermines themselves by showing their true colors as time goes on in these early interactions. For example, the communications, when they take a tone of urgency, they start to sound more like they're upping payments, they're making threats. Again, at that point, you recognize that this may be somewhat bad faith that you'd have to be more worried about dealing with. And then there's some companies who just say, we'll go in this conversation with them, but we know almost for certain that we don't want to pay, maybe because of company culture, you disincentivize future people, you just thinking that what they found isn't worth it. There's a lot of reasons that might go into that.
And it also sounds like it's an important component as to whether there is this vulnerability disclosure program, or maybe another name for that is this bug bounty program, which would perhaps describe some sorts of rules, parameters, and perhaps even commitments with respect to payment.
Yeah, so I'm glad you raised that. Again, I know I've already said a few times, but with the disclosure program being upfront and setting parameters, it helps make sure the parties are aligned on their expectations. Now, you can have a disclosure program without a bug bounty feature. Many people or companies opt to go that way. Some choose to be silent to allow flexibility. Some come out and say expectations, maybe because they don't want people targeting them, thinking that they will then have to pay out and say that as a matter of course, we'll never pay bug bounties. But yes, absolutely having those initial parameters set up helps so that you're not making some of these decisions on the fly under duress when you have had someone approach you.
Okay, so we're in the position where we've made a decision as to whether we are going to pay for this information, pay for the cooperation. We're making decisions guided in accordance with whatever disclosure program we have in place or bug bounty component that we have in place. How does this come to closure?
Yeah. So a lot of that depends on if you have an established program or not. So I'll start with if you have an established program, just because that's a little more straightforward. You would, again, validate if you look at everything and turns out it's true. You oftentimes may have contracted with a vendor. There's two larger ones, there are others as well, but HackerOne and BugCrowd, where they would facilitate payment as part of this. They have a process where they would set up terms, think of like a non-disclosure agreement or whatever terms you put in place around the payment, or maybe the disclosure happens only after you've come out with a patch. And as part of that program, they'd also make certain that the individual being paid is some level authenticated, that there aren't concerns around sanctions risks, which you've mentioned before, and we can talk more about. And again, at that point, it's very set up so that it's streamlined. Now, when you don't have a disclosure program, there are vendors you can do outreach with to set up for like a one-time payment. But same thing where it would be very important to do some sort of sanctions check. We bring this up because if sanctions is obviously beyond just a civil concern, criminal concern. OFAC has come out, and although very focused on ransomware payments, a lot of that same logic and requirements and the underlying law would apply to a payment to a security researcher. So you would want to work with a vendor who specializes and can do sanctions check and be able to confirm that this researcher is who they say they are. They're not a sanctions list. They're not a sanctioned location where you can't send payment. And part of that ties into a recent podcast that you all had around work with law enforcement in these instances. OFAC has come out and been very clear that should you work with law enforcement and you're disclosing information, that will be considered heavily mitigating. And so it's very much in your best interest, a scenario like this, beyond getting fidelity and threat intelligence information, to work with law enforcement before you would ever consider actually making payment.
And so, Dan, I mean, I think so everyone's going to be following this. And then, for those who have been down the road of saying, all right, well, what does this mean from a breach notice perspective? And should I be thinking of, whatever it is that I learn about from these researchers? Is that an incident? Is that an event? Is that a breach? I mean, it sounds to me like there's some big and important questions that need to be asked.
Yeah, I mean, absolutely. I would say, going back to your initial question when you're approached, I would treat it as the point of being an event before being a breach. Or when you look at certain breach triggers, almost all would account for exceptions where there's something either in good faith or there's low risk of harm. And so when we think of this, if this is a legitimate security researcher, has a history of finding these, maybe took very limited data just to identify proof of concept, but because of this, maybe they had access to something, doesn't mean that they actually then went in and took advantage of that access. Maybe they acquired one or two sample files as opposed to acquiring mounds of data. That all of those and more criteria will go into that analysis of, do we in fact have a notifiable breach here, or are we within one of the exceptions of the law that would allow us to say, again, this is really no different than an authorized user, doing a vulnerability scan and identifying something that needs correction, other than, this was someone who was maybe authorized instead under a vulnerability disclosure program, or quasi authorized if we're silent on that, and they went ahead and reached out to us proactively.
So sounds like it's very much of a fact specific analysis that would need to be undertaken from a breach perspective, including what is it that we learn about the threat actor and the scope of potential access or the scope of potential acquisition, and the way that we're able to verify the statements that were being made. Importantly, as I think about that, it is unlikely that a vulnerability was introduced and then immediately within a few minutes you were getting contacted by a security researcher indicating the presence of this vulnerability. What is more likely is that that vulnerability had been around for some period of time, and then the researcher found it. But we have no assurances, at least immediately, whether that vulnerability has ever been identified or potentially exploited by any other party. What does that context and that dynamic mean for your incident response?
Yeah, Scott, you brought up a really good point that even if you have a friendly security researcher and everything looks to be good, it doesn't necessarily mean you're out of the woods. And this is when you really have to hope that you have robust logging with long enough a period that it covers when this vulnerability or misconfiguration or whatever the cause is first introduced. So to your scenario, you could have, again, a very legitimate security researcher reach out to you, you confirm everything is valid, you have resolved it, patched it, whether or not you pay them, whatever, maybe they don't want anything other than recognition. You still then at that point, before you make a decision around your breach determination and risk of harm and all that analysis, do you have expectation of going back and conducting diligence and analyzing, have others potentially identified this and taken advantage that we didn't know? And sometimes if you have robust logging, you're able to find that out. And some of that is going through a process of determining what was legitimate access versus from your employees or items that you don't know. But then there can be scenarios where you don't have adequate logging, and then you really have to go through and consider, again, based on the facts of the scenario, the type of data, how long the vulnerability was available, risk of harm, just a lot of different considerations that would go into if you were to determine that you had notification obligations at that point.
And perhaps maybe another wrinkle on this complicated response is when I asked, or you earlier, I was saying like, well, we are paying for the time and the energy that the researcher had put into this. And we're also perhaps paying for the information that they can provide to us about how to address this. I think to make these dynamics even more complicated is that I mentioned a moment ago, the decision around payment. I said, well, we're paying for the information, we're paying for the time and expense and expertise that the researcher had gone through. But there's often a question of whether we are also paying for any form of confidentiality. Said more precisely, are we paying so that this researcher doesn't go out and tell the world that an organization has had this type of vulnerability, which I think as players in the space understand is that there is a significant legal issue surrounding paying third parties for not publicly announcing either data breaches or other data incidents that may otherwise require us.
You're absolutely right, Scott. It somewhat depends, again, on the nature of the vulnerability and what the security researcher accessed on a fact-based scenario. So I'm going to go through a first scenario is if this is a vulnerability, again, if you think you're a software company or a medical device manufacturer, something that you're going to have to go out and publish because you're coming out with a patch to people, there's less thought of this is some sort of cover up because you're going to eventually communicate to the larger community, hey, we identified this bug that needs fixed, and here's either mitigating items or a patch that we've released. So there's going to be less feeling of maybe a potential cover up there. But if it's something such as a data exposure, which is what we often come across, there are concerns around, is this appear to be some sort of attempted cover up? And a lot of that gets into a recent high profile case many listeners of the podcast are probably familiar with. And this involves Joe Sullivan, the former CISO of Uber, where he was convicted of criminal charges for payments to, I'm going to say, a threat actor via a bug bounty program where he used the bug bounty program to cover it up. Many listeners, again, are probably very familiar with this. I'm going to give the short version that's focused on the bug bounties, but if there are any listeners who aren't familiar, it's a really exciting case. I mean, it's wild facts. It's like we should do a separate podcast just on this. But for our present purposes, a key aspect of the government's successful charges against Joe Sullivan were that after being approached by threat actors seeking an exorbitant sum, he paid them using the bug bounty program as a guise. Importantly, the payment was $100,000, which was, to quote DOJ, the largest bounty that Uber had ever paid through the program, and it far exceeded the vulnerability disclosure program's nominal cap of $10,000. So then, as part of that bug bounty program, to your point about feeling like a potential cover-up, Sullivan had the threat actors sign a non-disclosure agreement. And it's fairly standard to have a non-disclosure agreement that in itself isn't problematic. What was problematic in the Sullivan case was that the non-disclosure agreement contained statements that were both contrary to standard bug bounty processes, such as saying that you would never be allowed to publish what you identified, and more importantly, that it mischaracterized the threat actors as not taking or storing any data during their research, despite Sullivan being aware this was inaccurate. Sullivan edited the draft non-disclosure agreement to add this inaccuracy. So that, again, was a very key point there. But takeaway from this case, and something that I know you and I have encountered multiple times, is these really wild facts have unfortunately been misinterpreted by CISOs and others to think that really any bug bounty payment may be seen as a cover-up, particularly if there is an existing vulnerability disclosure program, and that it's illegal and they're going to go to jail. And if you do it, they're otherwise going to be a whistleblower because they're so concerned about this.
Yeah, I mean, it's a very kind of interesting development, and frankly, I think scared many CISOs in the space and other folks who are helping organizations respond to incidents where perhaps for the first time there was a suggestion that some specific actions taken on behalf of a company may result in personal criminal liability. And, that is a scary component indeed. So as I think about where this leaves us is that, we have this community who's coming and identifying these issues. We have, as you were describing a strategy and approach, a bunch of legal factors that we need to be cognizant of and manage along the way. Where does that put us in terms of establishing our key strategy for these types of issues?
Yeah. So where I would say that leaves us in many ways is if you don't have some sort of vulnerability disclosure program at this point, it's in your best interest to get one. And if you do have one, you may want to revisit what you have. As a quick aside on that, beyond us just talking about this and being best practices and being ready for the random outreach of a security researcher, there have been recent developments or upcoming developments in the law that are going to really require a number of companies to have these, including the EU's Cybersecurity Resilience Act. FDA is now requiring this for medical device manufacturers, and NIST, which is a security framework used by many, has really put more of an emphasis on this. So with that all in mind, what are some key takeaways for, again, establishing that disclosure program, either because you want to get ahead of this or because you see things coming down and it's going to force your hand regardless of the law, is you'll want to have this so you're not doing it under duress from a security researcher reaching out. So the goal is really to align on expectations up front so that if a security researcher approaches you, they know what to expect and you've kind of laid certain guardrails so that they know how you operate and if there are going to be limitations for them to get payment or what the payment amounts may be. A key thing coming out of the Sullivan case is that you don't want to be too prescriptive necessarily as far as what you will and won't do. You want, how many times have we already said during this, talked about it being fact-based. You do want to give yourself that dynamicism necessary to react to the specific facts. But even if you decide that you don't want to propose bug bounties, you don't want to necessarily publish this, and some people choose to maintain a disclosure program or plan just that they have internally. And that is certainly an option if they want to go forward that way.
Well, Dan, this is, I think, really helpful, and I think gives, organizations and listeners a lot to think about as they are planning for the eventuality of this occurring, and how is it that they can get out ahead of these risks, especially by establishing that disclosure program early on to address these things and have, frankly, a plan. Because I think as all of the folks who are on the ground within incidents, is that having planned and practiced those plans make it so much easier for us to actually respond when the crisis inevitably arises.
Yeah, I totally agree, Scott. And one thing I would add here is that because this has become more standard and kind of an industry expectation, there are vendors out there to assist clients. I know many people might be listening and be thinking, this sounds like a heavy lift, or we're suddenly going to be inundated with all these vulnerabilities. There's ways you can set up your program to minimize the noise. The best programs I've seen are ones that almost take as much time saying what's out of scope and what you're not allowed to do as any other details, because that really helps avoid the noise. And then again, you can have vendors that can help facilitate this. They can do initial screening. There's a lot of help that makes this really less of a lift than maybe it was historically, again, especially as it's gaining wider adoption.
Well, Dan, appreciate your insights and practice points on this really important and challenging issue. Thanks so much for joining the podcast.
Thank you for having me, Scott.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.